Hello, my name is Stephanie Funbank and today I am going to talk to you about cybersquatting. What is cybersquatting? Cybersquatting, also known as domain squatting, is the registering, trafficking in, or using an internet domain name with bad faith intent to profit from the goodwill of a trademark belonging to someone else. The purpose of commercial gains shows either when the cybersquatter offers to sell the domain to the person or company who owns a trademark at an inflated price. This technique is also referred to as the ransom artist, or by generating revenue from advertising a competing service, also called the sneaky competitor. Other forms of cybersquatting are, for example, the porn funnel, employee hate sites, or suck sites. Cybersquatting in Australia. While cybersquatting is more common in relation to .com, .net, and .org registrations, cybersquatting on .au domain names does occur from time to time. Australian businesses and organizations that feel they have fallen victim to a cybersquatter who has registered an Australian domain name that is identical to their own business or organization name or a typo version of the same name should, as a first step, consult the .au dispute resolution policy, the AUDRP. In order for a dispute to be successful, it has to fulfill these three requirements. First, the domain name is identical or confusingly similar with the trademark of the complainant. Second, the registrant has no rights or legitimate interest in the domain name. And third, he is acting in bad faith. But how can cybersquatting even happen? The domain name registration operates on a first-come, first-served basis. Unfortunately, having a trademark or company name doesn't give a better entitlement to register a domain name. There is no general prohibition to register domain names if the trademark is owned by another person. The difference between trademark and domain name law is that a trademark gives an exclusive right to use it for certain goods and service classes, while under the domain name system there are no exclusive rights, which means that similar domain names to similar or different service classes can be registered. Earlier, there was a law that prohibited the transfer of domain names. In 2002, however, this prohibition was removed because it wasn't good. For example, if the whole business entity was sold, you couldn't sell the domain name with it. Nowadays, you can transfer any domain name after 6 months of registration time. However, there is still a prohibition in Schedule A of the AUDA policy that says that a registrant may not register a domain name for the sole purpose of resale or transfer to another entity. We see that cybersquatting is therefore still forbidden. How can you prevent cybersquatting? The WIPO Joint Recommendation on the Use of Concerning Provisions on the Protection of Marks and Other Industrial Property Rights in Science on the Internet addresses cybersquatting in 2 of their articles. In Article 3.1.e.2, it determines the factors for commercial effects in a member state. Most of the time, cybersquatting is committed to achieve a commercial effect. The link between the sign used and a right in that sign becomes relevant in 2 situations. Cybersquatting would be the most obvious case of unauthorized use of a sign. Thus, Item 2 would allow a competent authority to find a link between such cases of bad faith use and the country in which the infringed right is protected. Article 15 limits this prohibition to use a sign on the Internet because an injunction to cease every use of a sign on the Internet would go far beyond the territory for which the infringed right in that sign has effect. However, the provision does not completely exclude prohibitions of use, which can be justified particularly in cases of bad faith use, such as cybersquatting. The easiest and cheapest way to prevent most cybersquatting is to register a few basic variations of your company name before the damage is done. Which names should be registered? It is always advised to register a .com, .net, and .biz version of your company name. Furthermore, hyphenations of your company names and singular plural forms should be registered as well. To be absolutely sure, the trademark owner should register common misspellings as well as suck variations of this trademark or company name. Registering protective domain names is now becoming a necessary and expected cost for doing business on the Internet, a small price to pay to help protect against the time and expense involved in pursuing a cybersquatter. Thank you for your attention.